A watchdog group in Washington has filed a criminal and civil complaint against Justice Clarence Thomas after new reporting from ProPublica revealed billionaire GOP donor Harlan Crow purchased multiple properties for him for more than $130,000. Citizens for Responsibility and Ethics in Washington, also known as CREW, is asking the DOJ and Chief Justice John Roberts to investigate Thomas for failing to report both these real estate sales and the other, quote, lavish gifts given to him by Crow. A federal disclosure law passed after Watergate requires justices to disclose the details of most real estate sales that are over $1,000. In a statement, Crow said he purchased Thomas's mother's house to, quote, one day create a public museum at the Thomas home dedicated to telling the story of our nation's second black Supreme Court justice. Joining me now is Democratic Senator from Rhode Island and member of the Judiciary Committee, Sheldon Whitehose. Senator Whitehouse has been at the forefront of congressional efforts to hold the Supreme Court accountable on both ethical and transparency issues. A little bit more about this home or the homes that Harlan Crow purchased, specifically the mother's house. It appears that Clarence Thomas's mother still lives there, and that some renovations have been done to the house that she did not pay for. It's also unclear if she's paying any rent. I'm confused if he's trying to preserve this house to create a museum out of it regarding, how Clarence Thomas grew up. Renovations would kind of fly in the face of that, wouldn't they?
It might seem so, which is why investigation into all of this is so important. And by that, I mean independent, real investigation, not just relying on Harlan Crow's media comments. And I think that's why it's so important that the Judicial Conference, as I've asked, make a referral to the Attorney General, who has the power under the Ethics in Government Act and the responsibility to look into these things. And if, in fact, there was a negligent or willful failure to disclose, assess civil penalties.
So you're asking them to do that. What about the concern that DOJ might have about appearing political, going after someone like Justice Clarence Thomas?
I think it would appear a lot more political if you had a slam dunk case like this. The statute actually says if you have a real property transaction for over $1,000, you must declare it. There's no wiggling, there's no wobbling. This was a $130,000 plus transaction. So there's really no way to duck this on the merits. And I also think that you've got a lot of other judges, federal judges, looking at this, angry as hell, seething about the way these Supreme Court justices have behaved. And I think they'd feel very let down if the Attorney General walked away from this when they themselves would be subject to this kind of scrutiny had they done such a thing.
Have you gotten any response whatsoever from Chief Justice John Roberts regarding this?
No, not precisely this. And when I do send him things, he usually gets back to me either through the clerk of court or through the legal counsel. Sometimes the Judicial Conference steps in and takes over the way they did when they rewrote the rule about disclosing gifts to knock out this peculiar habit of the Supreme Court justices in not disclosing ritzy vacations that they get given.
Let me ask you about rewriting the rules. Who's in charge of making the rules for the Supreme Court? And is there a way to redefine it to make sure it's crystal clear for everybody what's expected of them? And also crystal clear for the public about the rules that the justices are supposed to be following?
Yes, and I have a piece of legislation that would do exactly that. The concern is that not so much that the court doesn't have an ethics code. There's a perfectly good code of conduct for federal judges. It's really just the choice by the justices not to allow any investigation or determination about their compliance with the code. So that's what needs to be solved, and it can be solved very easily because every single circuit court of appeal has a perfectly good process for looking into these things, and the Supreme Court could easily model a perfectly good process for itself on what all the other federal courts do. They just choose not to.